Welcome. Today, our webinar is entitled When Guardianships Go Bad. My name is Teresa Phillips. I'm an attorney here at Forster Bowman. A great part of my practice deals with adversarial guardianships, in addition to other adversarial matters such as probate and trust matters. So in that sense, I get to see a lot of guardianships that go bad, or at least more than probably the average practitioner. What we're doing today is trying not to go too much in depth in the ins and outs of guardianship structure and pleadings and things like that, but instead focus on some nuances on not the stuff that's in the checklist, but things that you should think about, that parties should think about, attorneys should think about, trying to keep this from being one of those guardianships that go bad. So with that, let's look at our agenda and how we're going to organize this today. In addition to the introduction just made, and we're going to look at also just some basic guardianship law terms and things, so that when we go through the various sections of the guardianship code and other legal matters today, that the terms will be familiar to you in case this isn't your area of practice. We'll look at when guardianships can just be bad from the start, scenarios that can set you up for a bad guardianship. We also will look at when we have a bad guardian, what happens. I'm gonna try to share some strategies to prevent a bad guardianship, some things that I've learned over the course of my career, and that my fellow colleagues here at Forster Bowman have helped me develop in trying to advise clients on ways to at least try to take steps to prevent yourself from being in the middle of a bad guardianship one day. We'll look at some case law, some recent case law on guardianship, and see what the courts are saying. And as always, we'll conclude with an opportunity for you to ask questions. I welcome them. If after the webinar you'd like to email me please, with a question or a war story about a bad guardianship, please feel free to do so. So what are we talking about when we say bad guardianships? You know, guardianships are supposed to be a way to help people who can't help themselves. But they give a tremendous amount of power to other parties. They take it away and they give it to third parties. So in that sense, it can be ripe for some wrongdoing, and for some whether intentional or unintentional, and sometimes they can end up doing more harm than good. So that's what we're going to be looking at today. Let's bad guardianship, as I'm using that term in this webinar, is a guardianship that does more harm than good to the person that it was meant to protect. So when you're looking at guardianship law, you're primarily dealing with Chapter 744 of the Florida statutes. The legislature put their intent in there when they reformed this chapter a number of years ago. And we'll go through the points that they put specifically in the chapter, and then I think you'll see a theme emerging. First is adjudicating a person totally incapacitated may be unnecessary. Second, the least restrictive form of guardianship is desirable. Third, permitting an incapacitated person to participate as fully as possible in all decisions affecting them. 4, recognizing private guardianship may not be an option for all, and establishing the office of public and professional guardians. So the legislature, when they redid the Chapter 744, they put forth these 4 specific goals or their legislative intent with this chapter. And I think if you look at those 4 there, you see a pattern emerge. Obviously, they're wanting to keep the loss of control, the loss of rights to persons who may be incapacitated to a minimum, to whatever's only necessary, and trying to, so while providing a mechanism to help everyone, including those who might not can afford a private guardianship, they also want to recognize that guardianship should not be any more burdensome than they have to be. They should not take more rights away than they should have. I want to just point out number 3, because I think this gets lost, especially on folks who've been doing guardianship even longer than myself, more than a couple decades, because I see this missed a lot, and it's permitting an incapacitated person to participate as fully as possible in all decisions affecting them. I hear so many times people say, well, you've been deemed totally incapacitated, so what you have to say or what you think about something doesn't matter. And that's not true. Now, there are certain people, depending on their incapacities and their disabilities, they may not really have a function to, you know, to participate in many of their decisions. They may be hallucinating, may be suffering from dementia and confused and think they're living 40 years ago. Those things obviously are going to have a huge impact on how much meaningful input they can have on decisions affecting them. But it doesn't mean that you shouldn't try as a guardian. It doesn't mean that you shouldn't see if there's some kind of input that they want, something that would make them happy, that while might not be ideal, is possible and would keep them safe. So I really reject this idea unless someone is not conscious or not able to communicate in any way. I don't really think that really applies to say someone's totally incapacitated. So therefore, I don't need to keep them updated about anything. I think that runs counter to the legislative intent as stated right here in the Chapter 744, Section 1012. Let's look at some basic definitions, just so when I use some terms throughout the webinar, you'll know what I'm speaking of. A guardian means a person who's been appointed by the court to act on behalf of a ward's person or property, or both. Incapacitated means lacks the capacity to manage at least some of their property or to meet at least some of their essential health and safety requirements on a day-to-day basis. 3, a ward is the person for whom a guardian has been appointed. It's the person that needs protection. A guardian advocate, I'm putting the definition in here because some people aren't familiar with that. And later on in the webinar, I'm going to mention in more detail how guardian advocates can come into play in trying to avoid a bad guardianship. So a guardian advocate is a person appointed by written court order to represent a person with developmental disabilities, but who is not totally incapacitated. We'll get into a little bit more detail on what that includes, but they're an option when someone doesn't need a complete guardianship. And they can even be, you can do a voluntary petition for that if you're a person who you feel like you need a person to represent you and things of that sort. So we'll look at that in a little bit more detail as we go through, but that's what I mean if I say guardian advocate. Not quite a guardian, but similar roles. Well, remember, to get a guardianship going, there has to be a petition filed, and usually that means 2 petitions. For a court to take away rights, declare someone incapacitated, they first have to make a finding and ruling of incapacity. Now, this doesn't apply if you have if, for example, you're trying to get a guardianship over a minor because their age itself is deemed to be an incapacity as a legal matter. But I'm talking about other people who otherwise, are of the age, and that they would be bound by all their decisions like any other adult. But for whatever reason, whether it be some kind of mental decline, disease, car accident, cognitive deterioration, chronic illness, something has made them incapacitated where they can't make those decisions about their person and property, at least in some to some kind of limited stance. That's what we're talking about when we're looking to have someone determined incapacitated. It's a legal term, and it requires a legal finding. So when you apply in these for guardianship, you're going to have a 2-part petition, or 2 petitions that's going to be reviewed in 2 parts. The first is, do we have an incapacitated person? And the second is, do we need to appoint a guardian? Because as we'll see later on, there's sometimes, just because you have incapacity or a level of incapacity, a guardian might not be necessary. So you'll start out with an application, and that's on behalf of the guardian. If they're not professional, they have to file an application that's universal. It's a pretty detailed application. You give your typical background check if you've ever applied for global entry or something like that. It'll be similar. You'll give where you've lived. You'll submit to credit history checks, background checks. You'll be fingerprinted. All those things. It's to ensure that we have someone who doesn't have a history of abusing elders, taking advantage, stealing, things that, or a felony of any sort, things that would deem you unqualified or unfit to serve. Then you got to file your petitions. And like I said, this webinar is not about getting into the ins and outs of what each petition requires, but look at the requirements. Specifically when it comes to petition to determine incapacity, you have to put a good faith basis, factual basis in your petition, in your verified petition. You have to tell the court what is it that makes you believe this person's incapacitated, not just a simple allegation. I hereby believe, swear and affirm that I believe this person's incapacitated, but you're supposed to give the factual basis, i.e., I saw this person, in their yard and they were not dressed appropriate for the weather. They seemed confused as to where they were. This has happened more than once. When I approached them, they didn't know who I was because even though we've known each other and been neighbors for years, that's a factual basis. Two, I saw this person, someone come over and a stranger and convince this person to give them money and scam them, and they seem confused and not able to manage their own affairs. Something like that is what you're looking for. Something that actually would be a factual basis, to have a good faith basis to believe they're incapacitated. That's an important one because that's one of the requirements. And sometimes I think it gets overlooked and someone just does have a good faith basis, belief that they're incapacitated. But two, if you don't have a good faith basis for filing your petition to determine incapacity, you open yourself up to sanctions in the form of attorney's fees and costs. Again, a petitioner is not expected to be an expert in this field. We can see behavior that would lend a regular person to be concerned and think there might be some incapacity issues, but that'll be determined by professionals later on and expert opinions for the judge. But you got to have some factual basis that a reasonable person would say, hey, yeah, that would give me concern too. So that's what you're looking for, your factual basis, show your good faith. And you also need some basic information about the person. You need to be able to give, identify them, where they live, where they are is going to determine, the proper venue. Be able to give at least who their family physician is or some sort of indication of their medical care if you can. All this will be important in the next processes after the petitions are filed. Then you have the petition to appoint guardian. And this one, you're going to have to address an issue called least restrictive means. You're going to have to explain to the court, even if this person's incapacitated, why is it that a guardian is necessary? Specifically, does the person have plans in place, assets in place, family in place, something that would make all this not needed, that it's just one step too far. So those are usually heard at the same time. In fact, a judge is not supposed to find someone incapacitated unless they're ready to rule on the guardianship matter, because you don't want to leave someone hanging out there. But you can see now why you need to think ahead. Be careful on what you put in your petitions. Think out what you're going to say at the ultimate hearing, and think about those issues and how they interrelate when you file your petitions. I'm not a fan of bare bones petitions. There needs to be some explanation in there as to why you're filing this, in my opinion. It makes you go through the thinking process. Is this really necessary? And makes you better prepared to address issues as you go through the process. Just as a reminder, any interested party can file a petition. And that's a pretty low bar. Okay. The third aspect I want you to remember during the petitioning process is there's an examining committee. And again, I think this is a reason why you think ahead in your petitions and what you include in them. The examining committee is made up of 3 persons. At least one has to be a psychiatrist or psychologist or a physician. And then there's 2 other members that can be an RN, a certified social worker, and there's a broad definition. And there's some other things listed, but there's also a broad definition. Anyone in the court's discretion believes that they have enough training or expertise in the area that they could be an expert in the area of determining incapacity. So but you're always going to have at least that one doctor involved. And why I interplay this with the petition is the first thing they see is what you filed in your petition. So if you've put some factual details in there, if you put witnesses, other people that they can talk to, if you've put the physician's name in there that they can call, this better prepares your committee members who are going to go out and examine the person in pretty quick order after the petition's filed. So again, you're helping them have the best understanding and have the best chance of doing a good, thorough, and correct examination. Bad information sometimes can get you a bad result. So think about your examining committee, think about the members, think about what they need, what can better prepare them for what's going to be a rather short visit, an examination, and try to include that in your petition or otherwise get it to your examining committee members in quick order. And also remember, the examining committee members are supposed to be communicating either directly or through an interpreter with the ward or the proposed wards in their first language. And I've had that issue come up, especially here in Florida, where we have a very diverse population. And when you actually dig in, and they did horrible on the reports, they couldn't answer any questions. And then you find out that the English wasn't their first language. And even if they're not incapacitated, but they're in a high stress level, and maybe English is their second or third language, they can, under those circumstances, they can misunderstand and not be able to recall their second or third language as quickly as maybe they could in more or less stressful circumstances. So always check and make sure that that you know what your ward's first language is, and that the members are communicating in that language either directly or through an interpreter. Otherwise, you might get some bad results. I mentioned least restrictive means. That comes into play when the judge is going to decide what kind of guardianship am I going to have? What am I going to let the guardian do, if anything? Again, as we saw in the beginning, the legislative intent, we don't need to do, even if someone's incapacitated, let's not do anything more than they need to keep them safe and healthy, and keep their property protected. So when you're looking at least restrictive means, look at things such as, does the person have a power of attorney? If they have a power of attorney and it's durable and your normal, wide ranging one that we see a lot, and even a more limited one, if it can take someone who's trusted, who has shown no signs of exploitation or anything like that, if they can pay bills, if they can access finances and control the bank account and make sure that the ward's not being taken advantage of, that all their bills are being paid, then why do we need a guardian, another party, to come in and do the same thing? In fact, you're supposed to disclose whether there's a power of attorney in your petition and other similar documents, pre-planning kind of documents. Durable healthcare surrogate designation. If the problem is if the person lacks capacity to consent to medical treatment because they've been in an accident or had a stroke or something of that sort, you might have a durable healthcare surrogate designation where there's a person that's already named to do that. Trust, do they have a trust? If they have a trust and their assets have been transferred to the trust, then you already have an administrator that can take care of their financial assets. If they were the trustee, the trust probably has language, or should have language, about a successor trustee in case of incapacity. So, and to the extent that there's assets that's not already in the trust, maybe it's better to ask the court to transfer the remaining assets to the trust. If you already have a trusted trustee who's managing more than half the assets, why not have them manage everything instead of having a guardian and a trustee doing duplicate work, incurring duplicate administrative fees, and more incursion on the ward's privacy. Remember plenary versus limited. If you got good examining committee members, they're going to go through and they're going to say specifically, do you need a plenary guardian, which is just full guardianship across the board, all rights that can be taken away by statute taken away, versus limited. And plenary shouldn't be used unless it's truly needed. And I don't know how many of you have ever actually looked at that list of rights that can be taken away. It's pretty extensive. I mean, I think probably the one of the most significant ones is they can take away your right to where you live, people you socialize with. And obviously when they take away the power to contract, you've taken away a plethora of rights from someone, because almost everything we do in society, there's some kind of implied contract from ordering something and implying that you're going to pay for it when you get it, to even being able to be employed or hire people to help you, such as a lawyer, to even be able to hire a lawyer to help you. So those are some really serious rights. It can take away the right to marry, the right to vote, the rights to drive a car. Again, your whole social environment can be dictated by a third party. I mean, think about it. As people have said, people who get a plenary guardianship, who are deemed totally incapacitated, they are probably have less rights than people in jail. To a large extent. I mean, it's an extreme remedy, and I think sometimes it's checked off without enough thought being put in as to, do we really need to check off all of these to address this person's current condition and concerns. So again, when you file your petition for a guardianship, make sure you're ready to tell the court if you think it needs to be a total plenary guardian, or if it may be more limited is more appropriate. Keep it in mind, again, we want the board to have as much control over their life as they can without subjecting themselves to unsafe situations. Now I'll come back to the guardian advocate. It's found in section 744-3085. Subsection 11 is wrong there, that's a typo. But our guardian advocates are again something that you should consider when you're thinking about least restrictive means. Can we appoint someone that has a much more limited role? In a lot of ways, it would be a limited guardian, because this person only has a certain amount of disabilities and isn't totally incapacitated, and that a guardian advocate can take care of the same sort of roles that are needed to fill in. I think that's why that section's been put in. The statute there says specifically courts are encouraged to consider this as a least restrictive means. And I don't see it come up as much as you would think in petitions, where people say, well, we've considered whether a guardian advocate would be sufficient, and this is why they wouldn't be. But I think given the legislative directive there, that courts are encouraged to consider guardian advocates when appropriate, that might be something that should be pled or at least addressed during their proceedings. So just to get in a little bit more specific, a circuit court may appoint a guardian advocate without an adjudication of incapacity for a person with developmental disabilities if the person lacks the decision-making ability to do some, but not all, of the decision-making tasks necessary to care for his or her person. And this was just recited again in a very recent case I have here, Tickton, that I'll get into, talk about in other contexts later on. But I do see certainly the legislature and the case law is reiterating that courts are encouraged to consider appointing a guardian advocate when appropriate as a less restrictive form of guardianship. And again, you don't have to have the adjudication of incapacity. You simply recognize that someone has some developmental disabilities and they need some help in some very limited aspects. Okay, so we looked at least restrictive means and the way to, and that's the first way you can get a guardianship that's bad from the start, if you haven't identified the least restrictive means and are utilizing them. Another way is if you've had a lack of good faith in the filings. As part of the petition process, you're supposed to provide a verified allegation of a reasonable factual basis for the good faith belief of incapacity. But sometimes people aren't acting in good faith. Sometimes we have bad faith. And, what's examples of bad faith? Your motivation is greed, maybe jealousy, maybe control issues. The classic case is that you see, I wish it was a rare fact pattern, but we'll look in one here in Florida later on in our webinar, and you see this very similar this fact pattern in other states and jurisdictions You know, one of the parents dies, surviving parent is interested in a new loved one, a new romantic partner, and the adult children are jealous, afraid that their, what they deem their inheritance is going to be spent on this new love interest, and or they just want to control the money and they don't like how the money's being spent. I hope it's clear on its face one of those would not be good reasons to try to have one of your parents declared incapacitated, but to say that doesn't happen it would just be inaccurate. It happens here in the Central Florida area, and it happens all over the country. So if you have someone who's given a bad statement, not a truthful statement about their good faith belief, and they're really motivated by other things, other bad faith motivations, then your guardianship's gonna probably be a bad from the start because it's not warranted. And that leads to a third issue that can make a guardianship bad from the start, and that's when someone weaponizes the guardianship. That's a term I've kind of coined over the years, and I use that when people's motivation with guardianships, which are meant to protect people, they are actually using them to control people or to get an advantage over people. And that does happen. And unfortunately, there's enough lacking in oversight protection in our statutes and in the system that allows it to happen. It's rare, I hope, at least based on what I've seen, but it does happen, and it can happen in the form of a private guardian or a professional guardian. And I've done this before and warned people that I see as a group that have the characteristics that you're likely to be targeted, and maybe be a victim of a weaponized guardianship one day. And obviously, it's, who's vulnerable, it's going to be usually older folks. Without a doubt, anyone who spends time around people who are getting older, those of us who are getting older people tend to have, they're going to have memory problems. It's just that's actually a natural part of aging. There's a big difference in forgetting forgetting what your, grandchild's middle name is, and then forgetting, that, what your name is. So just because someone has memory issues, and I even see that, the doctor said they have memory issues, that's really just part of being an older person, and that in of itself certainly shouldn't indicate incapacity. But when people are older and tend to forget, tend to be more fragile, tend to be more susceptible to suggestion, that can make you somewhat vulnerable for someone who's looking to weaponize the guardianship system to their advantage. If you have assets, obviously, when people are doing this, they're usually, maybe someone would want to do it just for the sake of control over another loved one or someone they have a relationship with. But usually it's people doing it out of greed. They're looking for people with assets that they can take full advantage of. They're usually people that have no family or close friends, or their close friends or other elderly people. And they're usually somewhat isolated. They usually don't have regular visitors, a social, calendar, and things like that. And I know there was a movie a few years ago back on Netflix called I Care a Lot. And it was a dramatized story about someone who was a professional guardian, but looked for people that essentially are in the category I just described. Even had, people, in certain fields and medical fields and care, elderly care fields that would look for these kind of targets and would make herself their, guardian under the guise of caring about these people, and would instead just, rob them of all their assets in the sense of, fees and things like that. So that's what I'm talking about with weaponization of guardianships. Usually it's someone that's using something that's supposed to be for the good, for the protection of people, taking a scenario and twisting it around and trying to take control over the situation just for the sake of control or greed, and not to protect the individual. So those are when your guardianship, no matter who the players are involved, is probably going to not end up well. Those are the situations where it just starts out bad. Now let's look at what happens when we have a bad guardian, or what's a sign of a bad guardian. A bad guardian can be someone with conflicts of interest. Not always. There's sometimes a natural conflict of interest. You're basically, telling someone they can't do things, and you get some benefit of it in the form of fees and cost and things like that. But I'm talking about things like you owe your elderly uncle money, and or have a sweet deal with your elderly uncle, where, I don't know, you get a car very cheap, or you get free rent, things like that, and you want to make sure that keeps happening. And when uncle says, I'm start showing some signs of maybe infirmities, I'm going to be your guardian now, and I'm going to make decisions. Well, you're not going to be a good guardian, because your interest conflicts with his. You're going to want to make decisions that keep you in good financial stead, that may be in conflict with what his long-term goals should be financially, and things like that. But sometimes a lack of education. I see people who want to be good guardians, but they just don't have the wherewithal and the resources. And that a lot of times depends on the ward. Sometimes you have wards that have, conditions that make them angry, make them violent. They're harder to, you can't find a place easy for them to live, an environment that's safe for them to live in, and have people living around them. And then they'll put them in somewhere just out of frustration, and thinking they have a lack of options, that maybe is not a good fit. And so you need to educate yourself. You need to find those resources. Elder affairs is a great place to start. But there's a plethora of them out throughout Florida. Luckily, we're a state that has a lot of elderly people, leads to incapacities and things like that. So, keep asking, keep your elderly advocating groups and things like that. Reach out to them and find out what is the best fit for your ward, so that they're as happy and safe as possible. You have to have a council of record in guardianships, and there's a reason. Have your council of record, use your council of record, use them as a resource. If you're having problems, bring it to their attention. Don't wait to the end of the year when it's accounting time or annual planning time and say, hey, they're living in a situation that's not working, or I can't get them to go to the doctor, or I can't, things like that. Use that. There's a reason why Florida requires you to have a council of record. Use them. If the guardian's going to be bad, if they're mismanaging the person, if they're making decisions on what makes their life easier and happier, and not what makes the person happier and safe. For example, I see people quick to put people in very restricted wards and facilities, when that person can probably do with less, but it's easy. And you don't have to pay it, someone to stay overnight. You don't have to, have, periodic reviews and things like that to see if they need to move to a more secure ward and things like that. You don't make sure the person gets visitors, or, encourage them to be part of social activities and part of their community, because, that actually takes effort. You have to go out and find things that would be appropriate for them. Oversee those things, make sure they're safe, make sure they're paid for, that is applicable. But that's part of managing a person. If you have control over their social aspects of their life, then it's your responsibility as a guardian to make sure that person has a good and fulfilled life to the extent possible. And then you can have a bad guardian who mismanages property. That's the one that will usually get you in jail. Right? The one that steals assets, doesn't manage them correctly, lets, property sit around without insurance, lets their, teenager drive the car, the ward, anything like that, spending money on things they shouldn't be spending on, any of those issues, and you've definitely got a bad guardian. So we've looked at what some bad scenarios are that is set up in guardianship, how you get set up for a bad guardianship. We looked at what bad guardians do. Let's look at, if you're a person, if you're a professional advising people, Are there strategies to try to keep yourself from one day finding yourself on the bad end of a guardianship that you don't want to be part of? And these are some strategies we've come up with. The first one here is a specialized trust and asset protection plan. You'll need good legal and tax advisors for this, but there are mechanisms that we found that at least reduces the chance that you would be attractive to someone who wants to use a guardianship badly against you, and it deals with putting your assets not in just a regular revocable trust, but putting them in a trust scenario and in a protection scenario where a guardian, whether court appointed or not, is not going to be able to access those assets, get paid fees from those assets, and therefore will not find you to be an attractive victim if that's their intent. Use the pre-need guardian when you can, and I certainly advocate that my clients do this as part of their estate planning. Section 744.3045 Florida statute sets forth anybody can go into the county you live in and file a document that says, in the event I am determined to be incapacitated in part or total, I want so-and-so to serve as my pre-need guardian. And you can have, like a durable power of attorney, you can have a backup. So let's say if nephew decides, the example we used earlier is wanting to have his uncle declared incapacitated so he can get control over his assets and keep having a sweet deal. It's not going to help him if uncle has a pre-need guardianship, because whoever he named is going to be named as his guardian, unless there's something that makes them not qualified or something very extraordinary. Pre-need guardians are given not preference, and a very strong preference. Let's look at one of the latest appellate decisions to see that. We have the Silva versus Silva case. It's a June 12th, 2024 decision from the 3rd DCA, so it's very recent. And they're talking about it's axiomatic that the trial court enjoys broad discretion in selecting a guardian. But it goes on to say, but that's not necessarily the case when you have a pre-need guardian that's been established. The discretion is tethered to an established standard. When a ward's preference as to the appointment of a guardian is capable of being known, that intent is the polar star to guide probate judges in the appointment of their guardians. So even and if you look at the Silva case, which we'll do in a little bit more detail here, but that was someone that the petitioner had been the pre-need guardian, but the proposed ward has definitely gotten sideways with that person since he named him pre-need guardian. But the court ruled that was his last known preference, and that has to be given tremendous preference in determining who will be guardian. So in that sense, you can control who will likely be your guardian, and by extension control whether somebody's going to want to get you involved in a bad guardianship. But again, as with anybody you put in a role of trust, name as a role of trust, such as a trustee, attorney in fact, and a power of attorney. A pre-need guardian needs to be someone you really trust, and you have to be honest with yourself. If you have family members or loved ones who are capable of letting greed or a bad situation control them, and not being able to look out for the interest of others, if they're selfish, if they're known to make really bad decisions, no matter how much you love them, don't name them in these kind of positions. Understanding how fees are awarded in guardianship also helps you think of strategies to prevent a bad guardianship. And this kind of goes along with the trust planning and asset protection we started out with as one of our recommendations. Fees can be awarded in guardianship, and we'll look at some stories here toward the end about some tremendous fees that have been awarded in guardianships that were probably what you would call a bad guardianship. And it's obviously can be a big motivator for people, professional guardians, private guardians, and even attorneys who are involved in these things. So understanding, though, what is actually supposed to be awarded in guardianships, I think would help, because I see awards and people asking for things that I don't think the statute covers. And people just presume it's a guardianship, and therefore all my fees as a guardian are reimbursed. And there's certain standards, and that's a little outside the purview of this, but I just encourage you to look at some of the more recent decisions, because I think you will see that the appellate courts trying to curve back. And when there's really not a legal or statutory basis to not allow fees to go out. And I think that's the trend, because allowing, just a blank check on fees encourages bad behavior. So this is the Ticton case. It's a very recent case, July 17th of this year. It's I think held the 4th DCA. So we had a husband and wife who had 2 special needs children. And what was being appealed was an award of $113,000 in attorney's fees against the husband. And the court went through and took the time to kind of sparse out what can be awarded and what shouldn't be awarded, and reiterated that you got to have a statutory basis. You can't just award fees and cost and guardianship. It's got to fall under one of the statutes and the clear language of the statute that award attorney's fees. And here it seemed like the court just, granted a pretty big amount. So what we had here, we didn't even have a full guardianship. We had a mother that was appointed guardian advocate. And the father unsuccessfully sought to discharge and replace her. And he alleged things like conflicts of interest and abuse of power. And not getting into the details, but apparently it wasn't found to be have much merit, if at all. So the judge awarded a number of fees, and the 4 basic ones was fees under a father not complying with a discovery order, because the father's affidavit was eventually struck for hearsay and speculation by the mother's attorney, because summary judgment was entered against the father's unsupported claims, and because the father had petitioned for interim judicial review and that was found meritless. And that's basically when you petition the court, you're supposed to have good faith grounds and a factual grounds that the guardian or the guardian advocate is doing a bad job. So all these things were against the father, and on that basis, he got $113K in attorney's fees awarded against him. The court said that they would only affirm for the discovery order and the interim judicial review, because those were the 2 that actually had the statute saying that they could be awarded. And yes, while the mother did, incur some fees about the affidavit and the summary judgment, there was nothing that specifically allowed awards under that. So I take this as a trend that I've seen, that courts are saying that, the days of just put your whole bill in there, everything you've ever asked the attorney since you've been named guardian or asked them to do is covered because you're the guardian, that you really need to start looking at and deciding what fees and costs incurred actually are covered by the statute. And there's a very detailed standard and criteria to get attorney's fees in guardianship matters, guardian advocate matters, and things of that sort. So that's why I thought that was a rather recent case and good to bring to everyone's attention. And I also think it helps in the sense that a guardian advocate, because they have less avenues to get attorney's fees than guardians, again, that might be a reason to advocate for a guardian advocate as opposed to a guardian. Silva versus Silva, we looked at this before. In this case, we had Dr. Orlando Silva, who appealed a ruling of limited incapacity, and specifically was upset about his son Jorge's appointment as guardian. This was the one where I told you the petitioner had gotten sideways with the person he had named as his pre-need guardian. That was Jorge. Dr. Silva, after his wife died, started facing some financial and health issues. He ended up moving in with his sister, living on a couch, and just seemed like things weren't going right. And it prompted his sons to seek an emergency guardianship. Eventually, the court ruled that he had limited incapacity after seeing the examining committee reports and taking testimony. And they appointed Jorge as guardian, despite Dr. Silva's, vehement opposition to that. The court reversed only on the evidentiary issue with extent of rights, but specifically talked about a pre-need guardianship is going to be given preference even in this scenario. unless the court could determine there was a reason why it would be harmful to the ward or potential ward. So again, the Silva case, I think it is recent, and it's showing a trend of holding up respect in the pre-need guardian statute. And that if you name that person, the court, and you come to on an incapacity hearing, they're going to presume that's your wishes as of before the moment you became incapacitated, limited, or total. So let's look at some examples of bad guardianships, and I think one, and it's a local one too. One of the saddest ones I've actually read about on a lot of levels is the Keegan case. And if you keep up with a lot of the local news, you may have heard about Doug Keegan. This was a man who was under guardianship for 7 years. Most of that time, he was living independently in a hotel in Kissimmee. That was because he kept escaping from wherever his guardian would put him. Which to me, and as the court eventually found to be the case, if you can do all that, if you can figure out how to get around people and you can go move into a hotel and live on your own, you're probably not incapacitated. So Doug Keegan was a retired engineer. I think he was also a Navy reservist. And he got put under a guardianship in 2014. He was diagnosed with a frontal lobe dementia. And I know, again, that's like the memory loss, things I see, that dementia cues people into like, oh, this person must need a guardianship. But I think this gives you an example. Look a little closer at what's going on. Because we'll find out later that diagnosis was wrong. But even if it should have been obvious that this man could do certain things. But he was put under a full guardianship. He was, like I said, most of the time he spent in a hotel, living on his own with his guardian finally just giving in. He had a professional guardian. His professional guardian finally just gave in and paid for the hotel because it was easier than trying to call the police and getting back to the living quarters all the time. He wrote to anybody who would listen for most of that time, and he finally found attorneys and assistants that would help him, which was hard because he didn't have control of his money. He couldn't pay anybody. In fact, he couldn't technically contract with anybody. And in fact, as I understand it, his professional guardian did try to run interference with him having a relationship with another attorney, citing that, he had lost that right. So by 2020, maybe when this really started at the end of 2020, when this became more of news and started getting some attention, the guardian and the attorneys had spent over more than $200,000 already from his assets. And by the end of the fight, it says it's reported that over $400,000 of his assets was paid for this guardianship. So you ask yourself, how did Mr. Keegan, and how in the world did he get in this kind of situation where it's cost him more than $400,000 in 7 years of his life, in which he had to live in a hotel and essentially stay under the radar from the police to be returned to his facility that his guardian had found for him. Well, Mr. Keegan met a woman from Kenya. By all means, they spent some time together. They eventually got married, and his children did not like that. And when they filed their petitions, I think this is an example of where, where we talked about how things can go wrong from the beginning. There were allegations of him being scammed by a Nigerian. There were allegations of she being a mail order bride. And those kind of terms, have connotations to them, that someone's being taken advantage of. The image of the Nigerian prince scam email comes to, starts going off in the neurons in your head. So it set a bad tone from the beginning. But when you really looked into it, apparently they had a real relationship. They visited with each other, and there was and that kind of language set up an idea of something that really wasn't going on. And then, of course, when later he was diagnosed after 7 years, when he got a new hearing, and the doctor said that was that dementia diagnosis was wrong, because he wouldn't have, their cognitive evaluations were saying no, someone with this kind of dementia, frontal lobe dementia, wouldn't be able to do the things he can do. So I think you look at that, and it started out bad. It had all those scenarios we talked about where you can get a bad guardianship. You had a guardian that I think did some things that were bad. If you've got a person that you're giving up on because they're out, they're more wily than you, and you're essentially letting them live in a hotel independently, it's hard for me to understand how you could advocate that they are totally incapacitated at the same time. And the fact that $400,000 in assets had to be spent during this time over what was probably a bad diagnosis, or at least what the court eventually said was, that to me is just an absolute tragedy, and certainly shows a flaw in Florida's guardianship system. And we can go through all the ways this broke down. But clearly, there were some bad players involved, whether that was intentional or not. And there was definitely some kind of breakdown in the diagnosis that the judge relied upon. And then I think what is the most troublesome is for 7 years, there was a living situation with this man that I think in and of itself proves capacity, at least to a certain extent, and that just seemed to be ignored. And not and Mr. Keegan had to work too hard to get that back to the court's attention. The good news is the judge ruled that Keegan's living situation itself proved his ability to care for himself, and lifted the guardianship. And what I understand from the latest interviews is he's living independently, and he's now advocating, telling a story, seeking reform of the guardianship system. Unfortunately, his guardian and his children that were involved, they had the court approve a divorce, which a guardian can do if you're totally incapacitated, and I'm guessing his relationship didn't work out. But that to me highlights what a bad guardianship is, and it also goes. You can see some of the scenarios we talked about how you end up with a bad guardianship. I'd like to tell you this doesn't happen all that often, but I tell you, I have become more and more convinced it's more often than we certainly should be. Just go up the road a little bit to Pinellas County. We have the recent case of Thomas Foster, 95-year-old, who currently lives with his his daughter, after he was brought into a guardianship situation after his wife died. It seems like he just fell off a little bit after his wife died, and instead of getting family involved, getting advocates involved, a full guardianship was rolled out, and he didn't need it. And now he's living pretty independent life, but under the care of his daughter at her home, and he volunteers for disabled veterans. But he spent 3 years and a lot of money under guardianship. We have the case of in Pinellas County too, of Tracy Samuels Hudson. She's a former president of a local guardianship association in Pinellas County. And she was just convicted of 8.5 years sentence for stealing hundreds of thousands of dollars from her wards over time. So when so I put these out there so there's an awareness that while it's still the exception, it's too much, and it definitely highlights and proves there's flaws in our system. And as responsible professionals involved in guardianships, I think it behooves us to be more aware of these situations, to work hard to make sure we don't find ourselves and or our clients in a similar bad guardianship situation, and do what we can to avoid falling into one of these pitfalls. Because I do think, at the end of the day, one of the saddest things someone can do in their later years in life is lose control over their lose more control than a person in jail or a prisoner of war does, simply because of bad people using the system in a bad way and not correctly. And so that's the purpose of doing today's seminar, webinar. It wasn't specifically let's get into the how to do a guardianship. We have a lot of webinars on that, but let's really think through and try to think to the next level when we're getting ourselves involved in guardianships or our clients are getting involved. And let's try to avoid being a story, on the news of a bad guardianship one day. So I hope this has been helpful. I welcome any questions. I welcome any suggestions to add to how to avoid these kind of situations. And I always encourage you to email me with any stories or questions you have as well. Thank you for your time. Thank you for joining us today. And here's my information if you'd like to reach out. You got my email address and my phone number. And please feel free to visit our website and where you can find links to other webinars we do. Thank you again.